Welcome to Real Talk, Family Law with Richard Lebovitz.
Hey everybody, welcome back to an all-new episode of Real Talk, Family Law with Richard Lebovitz. I'm your host, Mike Leon. You know, Rich here is a seasoned Maryland family law attorney with decades of experience helping clients through divorce, custody, and other complex family matters. And he's known for his clear, honest guidance and commitment to helping clients move forward. In today's episode, we're going to be talking about there's two very different ways to approach a divorce. There's collaborative law and there's litigation, and each path has its benefits and its trade-offs, and Rich is going to help you understand it all. So, Rich, first off, good to see you as always. Let's start with a basic definition here for folks that are listening or watching here. What is a collaborative divorce? How is it different from traditional litigation?
Again, thank you for having me on your show today, Mike. It's a pleasure. So the difference between collaborative law and regular litigation, really, it just deals with collaborative law. The goal, it's really a totally different, mindset. That instead of trying to litigate a case, filing a complaint, and going through the courts, collaborative law is everything happens outside of the court, and it's essentially a separate agreement with the ability to share additional information that would normally be inadmissible in a trial, with the goal of essentially like doing non-binding mediation, if you will, and bringing in all the experts and professionals along the way as a team to try and help the parties reach an agreement. So it's really negotiating a marital settlement agreement and a parenting plan, all done out of court, or with the idea of the goal being having the agreement done. And once the agreement's done and signed, then we can file a court matter to just put essentially the agreement on the record and get your final consent order for divorce and or custody.
Can you go a little bit more into the process of what it looks like in the state of Maryland in terms of who's involved? How are some of these agreements reached?
Sure. So essentially the client would as part of the agreement is that if I'm representing somebody in a collaborative environment, that I cannot then represent them at trial if we were litigating. So it's really, you're coming into me with the full understanding that our goal is to reach an agreement out of court and work with professionals. So the other people would be, you would be represented by myself. Your spouse would have usually their own attorney, and then we would bring on, say, a financial advisor, maybe a real estate agent, or a certified domestic financial advisor, a CDFA. We can bring in a mortgage underwriter, or anybody that would help with making financial decisions, and to help the parties figure out what their assets are and work together, whether even that's a therapist or other people. That essentially all the professionals you can think of that may be helpful along the way to reach an agreement are potentially available in a collaborative agreement.
Richard, in your years of experience doing this, when is collaborative law a good option, and what kind of clients tend to benefit the most from that approach?
Clients that have either significant assets and really, or probably just don't want the exposure of a court setting, or to say things that can't really be unsaid in a court of law, and they would rather try and work, believe that they are able to communicate well enough with their spouse to try and reach an agreement, that a collaborative process is probably the best fit for them.
And I'm sure the inverse is true of the flip side of this, which is, when is litigation better or even the only option?
It really, a lot of it comes down to what are the assets or what are the issues. And obviously, if it's just we've only been married for a few months or a year or more, with very little assets, no children, it could be a very simple, hey, let's just sign a very quick what's mine is mine, yours is yours, get it, and just get an uncontested divorce. But when you start having stock options and multiple, a house, a vacation home, and maybe different families, or you maybe relocated from another town, and you start having extended family and all kinds of other considerations, a collaborative process may be the best way to go. And save on, and it's better to reach the agreement that way than to have to spend time in a multi-day trial, which could be thousands and thousands of dollars, where the collaborative process could be a lot less expensive, with the goal of trying to reach that agreement.
So on the collaborative route, if is it risky if there's a potential, let's say, power imbalance in the relationship, or even a lack of transparency between the spouses? Is there a risk there associated with going the collaborative route?
I believe no, to the extent that the parties are able to exchange the documentation necessary to answer the financial issues, and have full disclosure on that, and between counsel and financial advisors on each side, working together to make sure that there's compliance there, then there should not be an imbalance. The goal with the collaborative process, I want to say, is really just the whole kumbaya idea, but we're all working together. But each party has a team, and the only way that's going to work is if the parties are cooperating. Because
Right.
obviously, if I can't even get a pay stub or bank records that I think I need to try and show something or prove a point for between the parties, then the collaborative process it will fall apart. The whole idea is we're all working together for the common goal of reaching an agreement. If that cooperation fails, then the whole process falls apart, and then you just have to go for the litigation side.
Richard, I think I've heard you mention in a previous pod about this collaborative light approach that you use in your own practice. Can you kind of explain what that means for our audience, and how does it compare to what we've been talking about in terms of collaborative law or litigation?
Sure. So in collaborative law, as I said, it's a special fee agreement. You're hiring me with the understanding that we're going to exchange information that may not be necessarily appropriate at trial. We're relying on hearsay or out of court statements that would not be admissible in court, or just basically bank records and documents that aren't properly certified as business records or whatever may be necessary at court. And we're exchanging information with the understanding we're going to reach an agreement. But for the litigation side, and when I say collaborative light, that basically means maybe before I file with the full intent of representing you at trial, I can say reach out to the opposing party saying, hey, why don't you just give me some mortgage statements, some pay stubs, your W-2s, and let's just exchange some basic financial information, assuming that we have a relatively easy, just a few minor assets and maybe some children to resolve for custody access. If we can reach that agreement, and sometimes the parties are like, hey, we're great friends. We just realized our marriage isn't working. And we can all very easily just come up with an agreement. And sometimes the parties already almost have the basic of an agreement. They just want the attorneys to review it. Again, I can go over that, draft it. I don't have to then go for the whole collaborative process. I don't then need to bring on a financial advisor and other professionals because they're not absolutely needed. So from a collaborative light, I'm sort of loosely doing what I would do in collaborative law, but I'm also have retained the ability to then file the case in court, because a party could come to me, hey, I think we can reach an agreement here. I would draft something, I'd send it to the other side, but if the other party won't sign it for whatever reason, I could still just file a complaint, and then maybe 6 months from now, when we're getting closer to a trial, we didn't reach an agreement. But at least I hold the reins and allows me to go to court with them. And to me, that's what that's what I prefer to the collaborative light process. But again, there are pros and cons, and for a case where you just may have some other assets, or you may need some help explaining what those assets are, the collaborative process can be a very good tool to reach that agreement and stay out of court.
Richard, I'm hearing dollar signs with all the folks that you've mentioned involved in this process. So, how does cost and time compare between the two in terms of the collaborative divorce and litigation? And what should people expect financially from this?
Well, to me, it's all about transparency. If I can be upfront with the client and explain, the difference between the different processes and essentially what it may cost. Sure, the upfront cost might be a little bit higher in a collaborative process, but the end result is reaching a result without then having to essentially air your dirty laundry in trial, months from now. Where if the goal is just mentioning all this information or getting it between you and your lawyer and some professionals, and with the understanding of reaching an agreement out of court, then it's a much more low-key, relaxed atmosphere. So, I mean, obviously, if cost is an issue, that's why these are things you would talk with your counsel, and we can work out possibly a payment plan and things of that nature to try and keep costs down. But yeah, that is definitely. I'm trying to be upfront and be transparent, and explain what the costs are with the client. And yes, it does cost some money to do all this. But from the litigation side, it's definitely scarier because eventually there will be a judge as the final fact finder who's going to make a ruling whether essentially whether you like it or not to end your case, which is why it's best to have the control and focus on reaching an agreement out of court versus having the pressure and time constraints of litigating the case.
Can you go through, if you have an example you can think of clients that have started the collaborative route and then they ended up in court anyway, and what happens in those type of cases?
Essentially, when the parties think that they have an agreement, they approach the attorney, or one attorney says, "Hey, I have a colleague who I work with nicely, and we can maybe let's all work together and try to reach an agreement." And after full negotiations and trying to reach that agreement, for whatever reason, it falls apart. Usually, it's maybe something happens in the relationship, or when the parties start thinking, "Hey, we're so close to this agreement, I can now move on and bring my new boyfriend or my new girlfriend home," or whatever. Then perceptions change, and then all of a sudden, well, wait a second, you just did where someone or someone does something essentially stupid, whatever, and all bets are off, and then they realize, or for whatever reason, one party just won't sign the agreement. Then you're basically the stalemate. So the only way to break that stalemate would be then to file the complaint and then start over. But by filing that complaint and the parties having not reached that agreement, now some may have to hire new counsel and go the litigation process. There are those days, though, even when you start the litigation process, you still have the framework for that agreement that potentially can be resurrected later.
Richard, for someone who's listening to this right now, they're unsure of which path they should go. What would you advise for them? Where should they start in terms of making that decision?
I would imagine if they would talk to either a financial advisor, and if they have a therapist or a marriage counselor, it could be very helpful tools. And also just schedule a consultation with myself or another attorney to basically ask those questions, and the attorney can help guide them to what may be the best path for them.
Richard, thank you for the time and insights on this. We truly appreciate it.
Well, thank you for having me again, Mike. It's been a pleasure.
And thank you to everybody out there listening to another episode here of Real Talk Family Law with Richard Lebovitz. When you're considering a collaborative process or you're considering litigation, listen, you deserve clarity, support, and legal guidance you can trust. And that's why you should go visit LebowitzFamilyLaw.com to learn more or schedule a consultation with Rich and the team. Don't forget to like, subscribe, leave us a review and comment on this episode. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.